So our next panelists are here, and today this is the nuts and bolts panel. Before the doors open, we're talking about the bidding process, the backgrounds, the financial, smart regulations, really those things that we'll be dealing with immediately. So we're using some of our panelists a couple of times because they have so much expertise. But we also have a terrific moderator here also. Robert Carroll, I'll be official. Bob's a former colleague of mine. He prosecuted some of the biggest organized crime cases in New Jersey. But he's been focusing on gaming for the last 20 or so years in private practice. And he's also the chairman of a tribal gaming commission, Chitamacho, did I say that correctly? Tribe in Louisiana. So he's got experience at all levels of government with gaming. So, Robert, would you come moderate this?
Thank you, Commissioner. Hope everyone had a good lunch, and we're honored to be here today. As Gail said, my background is a little bit different from some of the earlier panelists. I started out as a state prosecutor for many years, and then for the last 2 decades have been involved in gaming, and particularly in setting up gaming commissions and working in areas of compliance, regulations, and things of that sort. With over 28 states and 236 Native American tribes who operate in excess of 422 casino gaming operations, there's no shortage of regulatory experience and no shortage of regulatory missteps. To that end, Massachusetts is fortunate. They have the benefit now of being able to look at the many jurisdictions that have been involved across the United States and pick and choose areas that the statute requires regulations be drafted in. To that end, the actual regulations themselves oftentimes are the same as that exist in other jurisdictions. And because of that, the tried and true methods that are, say, standard, your base regulations, are then augmented and supplemented with those that the Massachusetts statute will add to it, and also with the policies and the direction that the Commission and the Commonwealth have set out. To that end, again, we have panelists here. You've met 2 panelists already. I'd like to introduce the third. Susan Yoakum is a Deputy Chief Counsel of the Pennsylvania Gaming Control Board. She has also been specifically involved in drafting regulations. And as Commissioner Cameron had said, we're here to talk about some of the nuts and bolts, to drill down a little bit into the system so that the public can be aware of some of the issues that we'll be facing. We thought it might be a good point to start with a couple of basic definitions. And one is the definition of regulation itself. A regulation is an authoritative rule dealing with details or procedure, a process of administrative legislation that constitutes or constrains rights and allocates responsibilities. Now, you're going to hear the term today, smart regulation. And that, too, now is becoming a term of art. And by a smart regulation, it's an initiative to ensure that an agency's policies are effective, that seeks to ensure a high-quality regulatory framework for citizens and businesses, and process ways of fully connecting and integrating an agency's responsibilities with the best interests of the affected citizens and businesses of the Commonwealth. Now, some of the noteworthy components of a smart regulation are careful evaluation of the costs and benefits of proposed regulations, potential effects on jobs in the economy, exploration of the least burdensome approach to accomplish intended policy goals, and improved transparency. An integral involvement with the industry involved in getting input from the stakeholders, in this case the gaming industry, the local governments, the surrounding communities, is all imperative in developing smart regulations. So to that point, we're going to start off with a little discussion about regulations themselves. The Commission will be tasked with putting forth a complete regulatory body in the next few months. That process has already begun. And to that end, we'd like to first address an issue to our panelists and say, as a general statement, what advice could you give to the Commission about regulations, and particularly smart regulations, that they may find helpful? If we could start on the end, maybe? We could?
Sure. I think, just to follow up on some of the things that Kevin talked about this morning, one of the things that we see in smart regulation is the use of technology. It is, as he described, so much easier when your applicants, especially for individual licensure, can submit their application via an internet connection. It's automatically there for your team to begin doing their investigation. So I would encourage you to take a look at all of the different jurisdictions, but especially Pennsylvania, because from my opinion, and I don't work there, they actually have the best from a technology perspective that's in place right now out there.
Kevin?
Well, I think, you know, when it comes to operational standards, you know, the regulations in any gaming jurisdiction pretty much have the same objectives: to safeguard the assets of the casino, to provide for an adequate audit trail, and to ensure accountability over those transactions. But those goals can be accomplished with being mindful of operator discretion in quite a few areas. So I think that the regulations that you draft should accomplish those specific objectives. But when a casino submits something more detailed in their internal control submissions, that will need to be reviewed and approved. Oftentimes, the approval of an internal control submission is delegated to staff and doesn't necessarily get placed on a public meeting agenda. Maybe the first couple of times it would go along that process. But in the internal control submissions, there's a much greater ability to incorporate flexibility, how a casino actually is going to operate the particular aspects of their casino.
I think it's also vitally important to reevaluate your regulations as you're going along. Pennsylvania's not been on board in gaming for very long, and yet the evolution in even Pennsylvania from where we were when we started to now, specifically one topic that comes to mind is vendors. Where we started with vendors, everybody had to come in at various levels of licensure. Where we are now is we've reevaluated and said, you know, we can pull back in some of these areas, and we aren't sacrificing any integrity by doing so. I also think it's vitally important to get feedback from the industry as well as the public. When our legislation was drafted, the legislature gave us the authority to write temporary regulations. Our board then opted to open up those regulations for a 30-day public comment period where both the members of the general public as well as the industry and our legislative standing committees had an opportunity to provide comments. We adopted several of them. They made a lot of sense. Others we didn't. Then when we moved from temporary then to final regulations, the industry was also given another opportunity to comment. It's an invaluable resource.
Excuse me, I just had one other
Go
thought
ahead.
that you might want to consider, and this is putting my operator hat on. If there's ever an opportunity to put a time frame within a regulation, I think one of the things that frustrates operators is something gets submitted and then there's no thought of how long is it going to take for either to get an answer yes or no. So if there are certain regulations where you can say, you know, if it's submitted and it's complete on day X, 60 days from now, we're going to give you an answer on it one way or another, that would be helpful from a planning perspective for operators.
And I think the operator deserves that timeline so that they, you know, that they know what they can, if they can move forward with a particular procedure.
I'm going to move into some of the more specific areas that are required by the statute and are touched upon in the task that's before the commission. There's going to be requests for proposals here, and there are different ways of writing a request for proposal. They can be tightly specified with a numeric ranking system, you know, very formal, or they can be more open and fluid and enable creativity by the applicants and the bidders. The innovation of the second method allows for perhaps the applications to be more varied and more wide-ranging. but that can be constrained by the RFP process itself. What are the pros and cons of these type of, the differences between those two systems? Allowing for an RFP that's very tight and very rigid, or something that should allow more operator input or applicant input? Susan, you want to start?
I would say Pennsylvania didn't specifically use an RFP process. I think the RFP process can be great at establishing a threshold in terms of who, from a threshold perspective, are going to be the people who you want to invest your resources in, and really evaluating whether they are a qualified applicant. So they can be, an RFP process can be used as a threshold requirement. As I said, Pennsylvania didn't specifically use that RFP process.
Well, and we used a one-step process. We announced at a public meeting that we would solicit bids for whatever license was open at the time, a Category 1, a Category 2 application. And then we would have online on our website the ability of any applicant to download the application form. And what I think is important, and Susan can elaborate a little bit on this, is that you be very, very specific as to what you expect the applicants to submit to you, including the order in which you want them. You'll have a basic application form, you'll have a set of instructions, and then there's a number of documents that you're going to want to get. And you want to specify attachment 1 is going to be, a site plan. Attachment 2 is going to be an architectural rendering of your project. Attachment 3 will be your letter of commitment for financing, all the way down to however many pieces of material you want to evaluate. Because as you get through that process of evaluation, you want to be able to go to each applicant and look at their material and know where you can make that comparison to evaluate it.
Yeah, and this does dovetail on the due process requirements when you're awarding licenses. Writing regulations, it's important that all applicants have notice of what the expectations are. And Kevin mentioned about making sure that subsection A is always going to be your financing, for instance. That makes it very easy for your staff to do a side-by-side comparison. I think it's important to have that process in place because the board, whatever licensing decision that they make on appeal, you're going to want to make sure that it's going to withstand judicial scrutiny. In order to do that, you have to ensure that all parties were on notice of what the expectations were, and all parties were given an opportunity to be heard. Yeah.
It's more likely than unlikely that the bidders who are not selected will challenge the decision that the commission makes.
Every licensing decision that the gaming board has made has been appealed to the Supreme Court.
Yeah. No, I was just going to echo the same thing. I think the specificity is important because you have to think ahead that whoever is not going to get awarded the license is going to appeal, and there may be not only those appeal rights, but there may be other protracted litigation, side litigation on those decisions that you make.
And that can substantially delay the opening of your casinos.
Yeah.
The Massachusetts law, the Massachusetts law also requires that the host community also have a say in, by referendum. Does that make a difference?
Well, it certainly makes a difference. It makes a large difference. We in Pennsylvania, I'm not exactly sure what the time frame is, if it's at the time that we solicit, well, it's not at the time we solicit bids, but at least 60 days prior to a public input hearing, which we do conduct, we allow for written submission of comments. And they're logged and they're cataloged and they're put in binders, and every commissioner receives that as part of the record when it's time to make a licensing decision. But we also do conduct public input hearings. Anybody in the community the local governing body can sign up and testify to any matter that they want at the public input hearing. The one that we had that had the greatest notoriety would be when a project fairly close to Gettysburg, in Gettysburg, Pennsylvania, was one of the 4 applicants for one license position. And, you know, the town there was pretty evenly split, but on both sides of whether a casino should be close to a national memorial park, you know, it was passionate. I mean, there were people that were really passionate that a casino should not be located near Gettysburg National Memorial Park, and then there were residents who were passionate about the need for the economic development and the desire for that economic development in that area.
And those were all factors that the board considered. It wasn't just the public input, it was, you know, your financial suitability, your suitability of your participants involved with the project. But yes, it was a factor that the board considered.
And I think when you think about these businesses that you want to locate and be here 50, 75 years from now, having strong host community support is critical to the success of those businesses.
In regard to the bidding process itself, many of the companies that are involved are also involved in international projects. And those international governments who are in control of the jurisdictions and so forth where these companies are operating have different business standards in many cases. The information that comes in about that company's performance in a different jurisdiction, is that an important factor?
Well, we treat the international operations of any applicant similar to if they have other operations in the United States. When that background investigation is assigned, that team of investigators are required to do a full investigation of their interaction both in other jurisdictions here as well as internationally. So we make it's the same approach. 2 or 3 investigators might go to Japan or might go to Singapore or might go to Macau, and they will have prearranged contacts with the regulatory authorities in those foreign jurisdictions. They'll have prearranged contacts with the law enforcement community in those foreign jurisdictions, and they'll go through the same process to vet the applicant to ensure that that company has not violated any criminal laws in that jurisdiction or any regulatory, that they're in good standing with the regulatory agency.
And most of your operators nowadays are licensed in many jurisdictions. So if their integrity is called into question in one jurisdiction, it has a domino effect in other jurisdictions. And most operators know that, so that I don't necessarily think it's going to be a big issue.
But just to supplement that, though, one of my very earliest assignments at the Division of Gaming Enforcement was to take a look at the Foreign Corrupt Practices Act. And there was some issue with an applicant or an existing licensee, and my recollection is that, yes, it did involve the country of Mexico. And you know, and that analysis is apropos today as much as it was in 1981. I do not believe that a casino regulatory agency would look kindly on bribery in a foreign country to get your goods in and out or to have your projects go smoothly, whether there's customs or norms along those avenues or not.
I think the other piece to that is that the companies that you're dealing with would presumably also have robust audit committees and compliance committees, and as another area where your investigative teams can get information, that would be a great source of what's going on within the company.
And I think we should make it clear that if a company is operating in a foreign jurisdiction and the standards in the foreign company are different, it's the standards of the Commonwealth that would be applied. So if, in fact, there's more strict standards in Massachusetts or in domestic operation or jurisdiction here, it is the strictest standard that would be applied in those circumstances. In our experience, we've all had situations where companies have been involved in conduct that was lawful in the jurisdiction that they were operating, but would not necessarily pass muster under a domestic jurisdiction here. And adjustments had to be made, and disclosure and so forth is critically important, so those items can be fully vetted and investigated, and a decision can be made. Moving on now to background investigations. I'm going to try to move quickly through some of these things to get as much information out. Let's talk a little bit about financial oversight also. There are various ways to do background checking. Outsource to third parties, hiring your own staff and so forth, but mindful of the fact that the initial operations, there will be somewhat of a tidal wave of applicants for the different positions and so forth. Can you comment a little bit on the methodologies that you've practiced in your jurisdictions about, for example, using the state police, outsourcing at the beginning and then moving into agency employees and so forth, conducting it, just to get to advise the public and also the commission as to what methodologies have worked in the past?
Well, I wasn't associated with the Pennsylvania Game and Control Board in the early years, but they did recognize the need to get assistance in conducting background investigations, and they did retain one or two outside companies to assist as they were building their staff to take over background investigations completely. And it was enormously helpful and allowed the process to move forward. With regard to financial information and analysis, we did recognize the need to have qualified people to be able to read SEC filings and financial statements and some pretty complex documents. So within our Bureau of Investigations and Enforcement, we have a financial investigations unit. And right now I think we have 6 people in that unit for the 11 casinos. And they, some of them have CPA degrees or certifications, but they are all capable of conducting a financial review.
Bob, could I interrupt and
Yes,
ask a question?
Yes, Chairman.
Because Kevin, I had a thought about this earlier when you went on an earlier panel, and in an earlier panel you said that the first thing in the legislation in Pennsylvania called for was the protection of the public interest or something like that. And now you're talking about outsourcing the background checks, but we've all read the grand jury report. It certainly made me think that the public interest was not particularly well served early on. And in fact, I thought the background check process was one of the things that was called into serious question. And I know you weren't there at the time, so hopefully you can look back, and be candid. But I think we'd like to know, what there is to be learned. There were mistakes made early on in the process in Pennsylvania, and all I know is what I've read in the report. But, it did not all go well. What can you tell us? What can we learn from the missteps that happened early on in Pennsylvania?
Well, the missteps that I focused on, Chairman, were those that I felt that we could learn from and move forward in a better, more transparent way. In Pennsylvania, the grand jury, whether it's a county-based grand jury or a statewide-based grand jury, can issue a report. And in this particular case, there was a 2+ year grand jury investigation of the initial licensing of the operators in Pennsylvania. In the report, they made 21 recommendations. About half of those recommendations suggested additional legislative reform, and half of them were items that the Gaming Control Board could unilaterally move forward on and make improvements. And we had already done half of those, and we continue to make those improvements until we finish them. Part of that I alluded to earlier was placing on our website more information about how we spend our money. One of the things that came out of that report, in my view, was the need to be good stewards of the money that is appropriated for the regulation of legalized casinos. And we have done that. We took a more proactive role in ensuring that we were spending the money in a reasonable and necessary way. For instance, money that you spend for training. It's an extremely important process to get properly trained. Today's proceeding is certainly an aspect of training for the Massachusetts Gaming Commission. Back in the early period of the Pennsylvania Gaming Control Board, there's a number of very good conferences around the country. Mr. Fahrenkopf, I think he's left, he's one of the major sponsors of the Global Gaming Expo in Las Vegas. You can see products there and slot machines there. You can attend educational seminars, and it's very well attended. And I went there almost every year. But in Pennsylvania, what happened in the earlier stages was we used that as a training tool, and we might send 12 people. Various constituencies felt that that was excessive. There's also other, other training mechanisms. There's other organizations. Some are international. We're very proud of the fact that our director of the Bureau of Licensing, Susan Hensel, is the president of the International Association of Gaming Regulators. But they occasionally hold their meetings in the United States, but they'll hold their meetings in Austria or Singapore. And we, we had 4 of the 7 commissioners took a trip to Rome, Italy. And they were castigated for how could they spend the money entrusted to them to go to Rome. We're past that. We're certainly more open and transparent, and we try and be good stewards of the money that's been allocated for our use.
Steve Persky mentioned earlier today in one of the other panels about the degree of respect that licensing in other jurisdictions should be given, in this case the Commonwealth. Obviously, it's an individual decision for each jurisdiction to make on an applicant. What other criteria would you deem are important or worth commenting on in the evaluation of applicants?
I would say your financial suitability, and that would be how much equity you're bringing to a project, where your financing is coming from, the overall look of your project, how many jobs are going to be created, how many jobs you anticipate will be created. Those are the key.
Well, we also required from our bidders that they submit an irrevocable letter of credit or a payment bond demonstrating that they could pay the $50 million license fee if they were awarded the license. And in consulting with my Bureau of Licensing director, she informed me that 3 applicants failed that point. So that made the process much more efficient because we didn't have to move forward with those 3 applicants. They could not produce that irrevocable letter of credit.
And I think that some of the discussion this morning was around the fact that standardization of the licensing process, which I do think is helpful because, if you filled out the form once and you're asking the same questions in 3 other jurisdictions, if there can be a sharing of that same information. But I do believe each jurisdiction has different standards that they want you to meet, and some may have a different focus. Again, going back to the policy statements in your legislation, and that's what has to guide you. From a personal individual perspective, I'm all for having to have a license standard or at least a minimum that you have to meet, and then each would go above it. I get my prints rolled every time I renew, and we don't even have an electronic system. So it does get to be a little burdensome, and if you're in a large company, which may be some of the applicants that you have, and this is, you know, the 101st application you've had to fill out a renewal you've had to do this year, sometimes that process can be a little overburdensome.
I mean, in Pennsylvania, we use a standardized form for our principals. It's a multi-jurisdictional base application. Then Pennsylvania has some additional questions. It's a Pennsylvania supplement. So those are the questions that are specifically applicable to either the Pennsylvania statute or the objectives of what the gaming board itself is trying to further.
Susan, I'll direct this to you because I know this is an area you specialize in. Could you explain the differences between, say, an operator, a casino operator license, and say licenses that are issued for vendors and ancillary businesses and so forth?
Sure. From the operator perspective, you award a license to the specific operator. Well, then you also have your classes of people who work for the casino, and that'd be your officers, owners, and directors, your key personnel who are involved in the operations, and then you have your day-to-day personnel, so to speak, like your dealers. So that's one area of licensure. Then you go into your manufacturers. Those are your IGTs, the ones who create slot machines and table game device equipment. With respect to vendors, those are your companies that provide goods and services to your facility. In Pennsylvania, we started out very rigorous, where we had very low threshold dollar amounts that would necessitate you to come in and be licensed and investigated. As time has progressed, we've reevaluated and said, you know, in a lot of areas, this doesn't make sense. So we've increased the thresholds substantially. It used to be $200,000. It's now $500,000 for our highest level of licensure. We've also included 16 exemptions for things that we just don't feel it's necessary to require that you be involved in oversight under the gaming board's jurisdiction. We just recently added an exemption for professional sports teams of Major League Baseball, the NFL, NHL. Just wasn't necessary to require the officers, owners, and directors of those companies to come in when they're providing advertising for our licensees, for instance. Schools were also included in the exemption area, universities, public utility companies, things like that.
Go ahead.
Just to elaborate a little bit on that is, you know, some jurisdictions, you know, will focus on gaming-related versus non-gaming-related companies in the vendor licensing. We kind of did that slightly different. We established a category all by itself for manufacturers and a category all by itself for suppliers. And these are manufacturers and suppliers of gaming-related goods and services. So then when we talk about vendors, and the legislature coined the word gaming service providers as a vendor, we're just talking about all companies that provide any type of goods or services, including the construction companies and the subcontractors in that category. And it's in that category that we started out with very low limits. Anyone who would do business over $15,000 with one casino or multiple casinos would have to come into the system. And we've raised that up to 100,000 threshold. So below 100,000, you have to, the casino has to submit a notification form to the board that indicates its intent to do business with this company, and they expect business to be less than $100,000.
Is your instinct, looking back now, would you say that if you had it to do over again, you'd start where you are now? And are you in effect saying to us, you know, you might want to start with these slightly lesser standards, less rigorous standards, or are you saying it's appropriate to start what might be overly rigorous and back off?
We followed that latter course, and we followed the latter course because in our research with other gaming jurisdictions, the information shared with us is that these companies that provide goods and services to casinos is an area of vulnerability or potential vulnerability to some type of inappropriate company doing business with a casino, or a company that might have a secret ownership interest with people who may not be suitable to hold a license directly. So, you know, the general rule is set the bar high, and as you get comfort in the system, readjust where you've set the bar.
And then on the flip side, one thing that you might want to consider, we talked about economic development and getting the casinos, once they're located, to be partners with some of the local vendors. You might want to think about how you set your thresholds and whether there are certain requirements that you may be able to implement that could help spur that partnership with local vendors on.
I mean, because you also don't want to discourage local businesses from coming in to participate, you know, to provide goods and services to your licensees because of the expense of doing so. And that's one of the reasons why I think Pennsylvania has kind of reevaluated where we are, is because we want to ensure that businesses in the local community, like the mom and pop shops, still have an opportunity to participate, considering there is an expense that comes with coming under the jurisdiction of the gaming board.
Right, it's your local flower shop. You want to encourage the casino to buy their floral arrangements there, and maybe that's a $20,000 a year investment that they make, which would be huge for your small vendor. But that kind of a number probably doesn't support them going through the licensing process.
And at the outset also, Chairman, you have the benefit of, well, you don't have the benefit, rather, of having past practice with these companies. You know, after they've established a history and that you apply the scrutiny that a gaming commission does to a business, you get a better read on them. So if there has to be any rollback of the standards, you have a demonstrated record that you can compare it to. Most jurisdictions that I've experienced do the same thing. They start off high and they roll back as necessary. Okay. Let's see. Commissioner Cameron gave me this list, so I want to make sure I hit every question here.
Well,
Again,
Bob, I had one thing I thought that would be instructive to share, is every jurisdiction might have slightly different criteria for what constitutes an automatic disqualifier from licensure.
Okay.
I'm not sure what the Massachusetts legislation, if it addresses that, but in Pennsylvania, our automatic disqualifiers are a felony, any key or principal license application, and that's a high-level executive with the casino operator or the parent company of the casino operator. It's an automatic disqualifier. Below the key, the gaming employee or supervisors of gaming employees, there's a 15-year rule. If the felony is older than 15 years from the date of the conviction, it's not an automatic disqualifier, but it is certainly a factor to consider in the determination of suitability.
Kathy, do you have anything to comment on that in terms of standards for disqualification?
Yeah, each jurisdiction is different, and I think that there's a pretty robust group of regulations out there for you to look at, to use as in guiding you in setting the standards that you would have. I think that the one thing is to remember that, you know, you want to be fair to your applicants. While there are certain things that are of such a level that obviously they're an exclusion, to provide a process that lets them have a hearing, especially as time goes by, as Kevin mentioned, is prevalent in most jurisdictions.
We'll make one exception, Steve, for a question from the audience. Go ahead.
The regulation that you're going to adopt with respect to the individual licensing process, based on the statutory reference that participation is a revocable privilege, the regulation should clearly articulate the standard of proof and clearly make it the obligation of the applicant to meet that standard, whether you call it reasonable doubt or clear and convincing evidence or preponderance of evidence, whatever it is. Standard should be articulated, and it should specifically provide that it's the applicant's burden to meet the standard rather than the burden of the regulators to prove him disqualified.
And then that supplemental discussion by Judge Persky also reminds me of the important issue of where, in the licensing decision process, your background investigators from whatever source are going to come up with persons that they recommend be denied a license. And there needs to be a due process system for any applicant to be able to challenge that adverse recommendation. In New Jersey, we started out with utilizing the Office of Administrative Law. And any contested case proceeding, whether it was on the licensing side or the compliance side, would be transmitted to the OAL, and it would be assigned to administrative law judge, and the regulatory prosecutors with the Division of Gaming Enforcement would put on the case for either denial or a sanction due to a violation case. Steve recognized that was an expensive proposition for all contested cases to be transmitted to the OAL, and he recognized that he and the commissioners had the ability and the qualification to act as hearing examiners. So he changed that system in New Jersey, I think, for the betterment of the whole process. In Pennsylvania, I'm continually amazed at the fact that we have an Office of Hearings and Appeals that is staffed by 5 people. That's total. We have a director who acts as a hearing examiner and 2 hearing examiners, along with a clerk of court and 1 administrative assistant. And they process an enormous amount of cases that need to be litigated before they get to the Gaming Control Board for an ultimate decision. Certainly a fair number of them turn out to be uncontested because the applicant may have initially sought a hearing and then didn't show up for the hearing or didn't request a hearing. So if there's no hearing requested, there's no report and recommendation. It just goes through the process. But that is a decision that this commission will need to make. How are you going to set out rules and procedures to handle contested cases?
With regard again to financial oversight, what structures, what is the role of the Gaming Commission in financial oversight? And what methodologies have you, in your experience, you've utilized?
Well, the process that we utilize in things like refinancing or new equity offerings and that area, we do require all casino licensees to agree with a statement of conditions when they receive their license and at any point in time when they are renewed. And it's an extensive set of requirements.
Can you give some examples so that everyone...
Well, the examples are, that is the document that we rely upon to ensure that they give us prior notification of any potential transaction where they're going to refinance or increase the amount of debt load that they have. And they have to do that before the transaction is consummated. Gives us an opportunity to look it over. If it's not a complicated one, we will just, our financial investigations unit will prepare a summary memorandum, and it will be distributed at an executive session. Our board holds executive sessions the day before a public meeting so that they can engage in quasi-judicial deliberations. They'll be given a binder of what is on the agenda for the following day. And the statement of conditions is the vehicle through which the casinos are obligated to give us notification of those financial transactions, along with a whole host of other requirements, including the point that we just made on if you set threshold limits for licensing vendors. Every casino in Pennsylvania is required on a monthly basis to send their disbursements list electronically to the board. And we link that up with our system, and we can tell you exactly what companies have received payment from the casinos, and we can monitor when a company reaches the $100,000 threshold to require registration, or the $500,000 threshold to require certification.
Kathy?
Yeah, I think, Bob, in the last 4 years with the state of the economy, the question of the financial stability or financial wherewithal of casino companies, like any other company that is out there, has come into question. And I would suggest to you that we still haven't gotten past all of the economic downturn that we've experienced and started to move forward. So I would suggest flexibility. I think that, you know, every company files quarterly financial statements. Every company has auditors that they use routinely. There is a lot that can be looked at by your investigative teams as you go along in the course of a year, so that it doesn't just come down to an annual review of the financial qualifications of company. And that constantly being, having your financial folks talking to the CFO at the property and those sorts of things can help get you some feel for where those companies are going. And of course, as people are giving you their applications and their projections, your team will have a feel for, are they getting to the numbers that they said they needed to get to or not.
And in Pennsylvania, financial suitability, well, suitability in general is an ongoing requirement. So it's not, we don't just look at your financial suitability, you know, at the time of renewal or, you know, at the time of initial licensure and then leave it alone. It's a continuing obligation. And those, your numbers and where you are revenue-wise, that's our financial investigations unit routinely is evaluating that information.
And long before you get to the regulatory oversight, you also have the companies themselves that typically will have audit committees that they'll have in place. There'll be external independent audits that are done. There's compliance committees which have a responsibility to assure compliance with the applicable laws and regulations. And all of those internal safeguards as to the financial stability and financial tracking are required of the companies. And the layer on top of that of the regulatory system has access to all that information and obviously can verify, and what we talked about before, trust and verify. The opportunity to verify and the opportunity, more importantly, to investigate is present at all times. Just getting down to the bottom of the list here, there's some areas, just in terms of the review of applicants. Could you just provide some of the criteria that you've used in your experience to evaluate the veracity of applicants? I know that's a broad question, but just so, could you highlight some things that you feel would be something to pay attention to going forward?
Well, the applications are for keys and principles. A couple of the things that we did to improve that process.
Thank you.
Actually, it was done at a legislative level, and we supported it 100%. A provision was put into our act in early 2010 that requires all applicants for a key license or higher to submit a Freedom of Information Act request to any federal or state agency that the Bureau of Investigations and Enforcement requires them to make that filing. And along with the basic FOIA request, the applicant is required to sign a waiver that authorizes the information to be sent directly to the Bureau of Investigation and Enforcement. And you know, we have received responses from the Federal Bureau of Investigation, and it's then the responsibility of the investigator to conduct a thorough vetting of that information to determine if it can or cannot be corroborated. And that involves direct contact with the FBI, direct contact with other law enforcement authorities, usually a sworn interview of the applicant, where the applicant is questioned about the information received. And in some cases, it's determined that the information could not be corroborated, that it was strictly intelligence, that there was that there was no basis in fact to indicate that any of that derogatory information was credible, and the person would still be licensed. But that would all be in the background investigation report that's provided to the commission prior to them making a decision.
Kathy, you have some thoughts?
Bob, I think that every jurisdiction that I'm aware of still requires at those certain high-key principal employee levels that an investigator from either state police or someone in that realm goes out and does a personal interview with them. And I can't think of any better way to judge somebody's veracity than to sit face-to-face and have them explain their financial statements or whatever it is that the question's about. And I think that gives you a good feel of comfort.
Mm-hmm.
Just as a broad perspective, as a commission, it's going to be entirely up to you who it is that you want to require to come in. Who from your officers, owners, directors, your very key people, and then once you decide who you want to bring in, what level of licensure you want an investigation, what kind of background investigation you want to do on the various persons involved in the licensing process. Because obviously your key people are going to be investigated more thoroughly than your dealers and your lower level employees. So that's also another consideration that the board's going to want to take into account.
Mm-hmm. Okay, here's another topic. This is our first Twitter question that we have time for. Will you make casino operators share information about money spent on PR and advertising to influence voters? Is that an appropriate criteria, a requirement? Let me put it that way. Is it an appropriate requirement?
The gaming board didn't have any requirements regarding advertising other than making sure they had compulsive and problem gambling information contained on all of their advertisements. Beyond that, the gaming board didn't go in that direction.
Mm-hmm. Kevin?
I concur with my colleague.
Okay.
Could I ask a question as to whether or not you have any requirements for disclosure of contributions to public officials, elected or others, or to charities that may exist in various towns where casinos are seeking to operate?
Our Gaming Act is very specific that if you're going to be an operator of a casino, you cannot participate and you can't contribute to political candidates in the Commonwealth of Pennsylvania.
On the state level.
On the state level.
And how do you determine when that ban begins? Because if somebody is an applicant or going to be an applicant or thinks they might be an applicant, I mean, all those are various different
I believe it's the date of the submission of their application.
Yes.
That is the beginning date.
So it's a going forward matter.
And we also have a provision that places a responsibility on the casino operator to ensure that none of its employees have made such political contributions.
And that's designed to protect the integrity of gaming, that that the commission isn't influenced by politics.
Yeah, every jurisdiction I've worked in has had a prohibition, so it hasn't been an issue, but there is the ongoing obligation to make sure that your key employees at a minimum have not had any involvement in political activities.
The only thing I'd add on this is, kind of breaking this question down a little bit. If a casino is spending, over the threshold amounts on advertising or PR and so forth, that would be picked up in the vendor process if there are vendors supplying those services.
That's correct.
So that would be something that would be recorded and would be documented, okay, if that clarifies it at all. Okay, anything else you'd like to add that you feel would be instructional or helpful?
Well, there was a comment about casino credit, and I do believe that casino credit can be adequately regulated in a casino context. And if you look at the New Jersey regulations or the Pennsylvania regulations, it's an applicant for casino credit has to disclose quite a bit of personal information, information about their current indebtedness, sources of their income and their assets, and the casino is under an obligation to rule on that credit application based upon the applicant's creditworthiness. So it's a good process, and it pretty much in our experiences, it's to those serious gamblers who have resources that that they're able to utilize in the activity that they choose, and they don't want to bring that kind of money down to a casino. But in looking at the mantra, trust but verify, in the area of casino credit, it's don't trust and verify twice.
Okay, anything else anyone wants to add?
Is there a general smart regulation prototype out there? Is there an agency or even a manual or someplace? Is there some place where the smart regulation has sort of been codified to a usable extent?
Well, you know, everybody on the East Coast has always used New Jersey as the model of regulatory practice. And in New Jersey, they started out by specifying the rules of the games that, you know, they wanted to, here's how you're going to play blackjack. And they can be expanded to allow for optional payouts. They can be expanded to allow optional wagers. So there's flexibility that allow one casino to differentiate itself from another casino. But they are the model. And Pennsylvania looked at New Jersey first and foremost, and even the East Coast Indian tribes have looked to New Jersey. When I went up to Turning Stone and looked at their system of internal controls and their compact, it incorporated standards that have been tried and true in the New Jersey model.
Now, with respect to Pennsylvania, our legislature did something a little bit different than New Jersey, and that is they didn't allow a deduction for bad debt. They took that out of the equation. So if debt went bad, the casino operator doesn't get a deduction from revenue for that. So it kind of took the, you know, there's no incentive for them to, you know, to give credit that people can't pay back.
Casino credit.
Casino credit.
How about plain English regulations? Is there any process that you use or that you're aware of anybody else using to test regulations for their comprehensibility to a broad segment of the populace before the regulation is promulgated?
Well, in Pennsylvania, the structure that the Independent Regulatory Review Commission has set up is it's a two-step process. You have first a proposed rulemaking that goes out for public comment. The Independent Regulatory Review Commission also has agents that review it for you know, legality. They review it for clarity. We get comments all the time back from them saying this needs to be more specific, or this needs to be, you know, we don't understand exactly what it is that you're saying, or that you want to require an operator to do. So we had the two-step process is invaluable because it gives us kind of a second bite at the apple to make sure that our regulations, by the time they are final, are clear and understandable, that the expectation is known.
There's a clear, I mean, the core documents, Commissioner?
Actually, I had a question related back to financial suitability. Many of these companies clearly are global companies and with many subsidiaries, et cetera. Of course, how is this financial suitability overseen at a state level, wide level, global level?
You guys want to
Yeah, I believe that they're looked at on a corporate basis. I mean, certainly you'll have the individual, either daily or weekly, depending on how you set up your system, numbers that are coming in from each of your properties, and depending on when you're going to have them make their tax payments, I would assume that that would be more frequent than not. So your financial team will quickly get familiar with what their patterns are, and they'll be able to tell you, and you know, in New Jersey, when I was there was a weekly report that came out, and it told everybody where each of the casinos were based to where their projections were, simply based on the tax revenues that came over. But I do think that because they are now international companies that you'll be dealing with, that you need to look at the companies on a more global basis and take a look at the corporation versus just the individual property.
The key is you have access to it. I mean, again, licensing is a privilege, so they will, you know, they are compelled to provide the information for your examination. And a degree of scrutiny you know, can vary, okay, depending on your experience with the company's reputation, its current financial situation, and so forth. But I think it does start with the corporate level internationally. Sometimes you get cooperation from the other, you know, the other gaming commissions in the different jurisdictions, and that's where the MOU process comes in, exchange of information. Okay, Commissioner? Thank you.